You have a temporary work or study permit, a stable income, and you want to stop paying rent to finally own a home in British Columbia. But behind that straightforward goal is a regulatory framework designed to keep that door locked. In 2023, the federal government enacted the Prohibition on the Purchase of Residential Property by Non-Canadians Act. This nationwide ban on foreign buyers has since been extended through to January 1, 2027. Violating this act carries a $10,000 fine for any party involved in the transaction. More significantly, the Canadian government has the authority to apply for a court order to force the sale of the property. Because federal law begins with a baseline prohibition, temporary residents cannot start the buying process without first proving they fit into a narrow set of legal exceptions. For work permit holders, the primary exemption requires the buyer to have at least 183 days of validity remaining on their permit on the exact date the property is purchased. International students face a more rigorous test. They must provide evidence of having filed income taxes in Canada for 5 consecutive years and prove they were physically present in the country for at least 244 days during each of those years. This bar chart compares the federal government's maximum purchase limit for students, capped at $500,000, against the actual average cost of a home in British Columbia. Because of that price ceiling, the student exemption is functionally unavailable for the vast majority of BC real estate. Passing the federal test simply grants the buyer the legal right to purchase. It does not exempt them from a secondary layer of provincial regulations that carry their own costs. Federal permission does not prevent the province of British Columbia from applying its own tax measures. These provincial rules are independent of Ottawa's regulations. The central provincial measure is the Additional Property Transfer Tax, which is applied to transfers of residential property to foreign entities or taxable trustees. This tax applies to specified geographic zones, including Metro Vancouver, the Fraser Valley, the Capital Regional District, Nanaimo, and the Central Okanagan. In these areas, the tax rate is 20%. On a $2 million property, this adds a $400,000 obligation. This tax can be refunded, but only if the buyer officially becomes a permanent resident or Canadian citizen within exactly 1 year of the property's registration date. To maintain eligibility for that refund, the buyer must also move into the home within 92 days of registration and live there continuously as their principal residence for a full year. These rules force temporary residents to coordinate their purchase with the precise and often unpredictable timing of the Canadian immigration system. The 20% foreign tax does not replace the standard property transfer tax. It is added on top of it. Closing costs in BC scale rapidly. You pay a baseline property transfer tax on the first $2 million and 3% on the value above that. Over $3 million, the province adds another 2%. The 20% foreign tax is then applied to the total. When these combined costs become clear, buyers may look for a way out of the contract. British Columbia's home buyer protection period provides a narrow window for this specific scenario. Under Section 42 of the Property Law Act, a buyer has a statutory right to rescind their offer within 3 clear business days after it has been accepted by the seller. However, exercising this right triggers a mandatory penalty. The buyer must pay the seller 0.25% of the total purchase price, amounting to $2,500 for every $1 million of value. In British Columbia, even the decision to cancel a contract after signing carries a significant financial price, making every signature a serious liability. Successfully closing the deal and paying the initial taxes does not end the owner's financial or reporting obligations to the province. Owners must still navigate the speculation and vacancy tax, which requires a mandatory declaration by March 31st every year to avoid automatic assessments. Starting in 2027, the tax rate for foreign owners and untaxed worldwide earners will increase from 3% to 4% of the property's assessed value. The province treats these properties as a recurring source of revenue, taxing the owner annually as long as they remain a foreign entity under the Act. Many temporary residents assume that owning a home in Canada will strengthen their case for remaining here permanently. Legally, however, property ownership is considered a passive investment. It provides 0 points toward a permanent residency application and offers no basis for extending a work or study permit. Canadian immigration law is clear. Capital does not grant legal status. A temporary resident's housing goals exist in a completely different legal realm. For a temporary resident, buying real estate in British Columbia is a complex financial operation that exists entirely outside the path to Canadian citizenship.